This is a case that is not getting a lot of attention, it seems to me, in the sort of like broadly speaking in the media, but it really it can seriously implicate the lives of many, many Native American children.
Of many Native people more broadly. And I think it's worth noting this is a case about child adoption, right? It has drawn the attention and support of almost every major conservative corporation and law firm in the country, who have all weighed in against Native people and Native families and on the side of white families who want to take these children away from their tribes and essentially assimilate them into white culture. That's not a surprise, because the conservative legal movement has been attacking what we call Indian law for many years now. Why? Well, Indian law protects reservations and tribes from a lot of corporate exploitation and state exploitation. It protects the states from basically seizing these children from reservations and adopting them off to white families. And it prevents states and corporations from buying or exploiting land that tribes are located on and taking natural resources like oil that happen to be under them. And so this is actually about a lot more than just adoption. That is kind of the entry point for a case that's really an existential threat to Indian protections more broadly.
All right. And I just want, I want, before we get into the details of this case, I want you to just sort of make this more clear, is that the idea is that if certain principles can be established in this case that has to do with adoption, they can be carried over into cases that just simply have to do with Native rights over property. And therefore, you're getting corporations involved in something that has really nothing to do with them on its face, but they are looking to develop principles that can then be carried over into these other cases that have to do with just about money and exploitation of resources.
Yeah, that's exactly right. So look, the central argument in this case
is that— Can we just say, stop here for a moment and just like, people have to understand just like how twisted and warped this is. And this is the thing, I think, from a legal perspective, like this is the way things are done. A case that was decided 14 years ago and something written in the dicta or in the dissent by, one judge can be relied upon by an entire court 15 years later to completely upend something. I mean, we sort of saw that with Dobbs in some respects. Although it was more wholesale, just whatever, we're just going to do whatever we want. But that's what's going on here, is that the way that lawyers and the law is constructed, principles that seemingly have no relationship to a hypothetical case in the future end up being very important to that case.
Yes, that is exactly how this works. That is why Clarence Thomas was writing about the Second Amendment in the 1990s when nobody was paying attention. And then 15 years later, the court transformed his individual writings into the law of the land. So look, the central argument in this case is that it is unconstitutional, a violation of equal protection, for the federal government to classify people on the basis of Indian status. Now, there's a couple of problems with that. Problem number one, the Constitution itself classifies people on the basis of Indian status. This is something that is written into the Constitution. Problem number two, the Supreme Court has said for many, many years that Indian status is a political classification, not a racial classification, because what it actually asks is whether you are an enrolled member or a potentially enrolled member of an Indian tribe, which is sort of like having nationality in another country. Right. Yes, it has a corollary to race. Yes, if you're a Swiss citizen, you probably are descended from white people. But it is not classification on the basis of race. But because the court has been so hostile to Indian law over the last 2 years, basically since RBG died, these corporations think that they can destroy this entire body of federal law that is protecting tribes from exploitation on the basis of their Indian status. That is, for instance, tribes cannot just sell their land to corporations. States cannot seize tribal land the way they can private private land. There are all these rules and regulations that protect tribes from abuse. And one of them is, in this case, states can't take Native children away from their tribes and adopt them off to white families. Now, the central argument in this case is that that law is unconstitutional, that classifying children on the basis of Indian status is unconstitutional. But it's not going to stop with kids, right? We all know that this is laying the groundwork for future cases that gives states and also private companies these long sought after rights to start attacking tribes more broadly. And so I wish this case got as much attention as it deserved. In some ways, it's more important than the affirmative action cases. This is about destroying an entire segment of federal law protecting tribes and their members and opening them up to the kind of abuse and exploitation that went on for far too long throughout the 18th and 19th centuries.
So what are they looking for? The argument being that that states can have an overriding interest, or that essentially these treaties and what we've written in the context of the Constitution are they're not sacrosanct, I guess, and that there are, as long as once you develop the principle that there are circumstances where we can supersede this, then it just becomes ultimately a negotiation as to what the circumstances are.
Right. I mean, look, this is all just replaying the fight that went on in the 1820s in this country when states started seizing tribal lands and the federal government tried to stop them. And states said, no, you won't, which eventually led to the Indian Removal Act. The state of Texas, which is an actual plaintiff in this case, says we don't want to have to abide by federal Indian law. We are a sovereign state and we deserve the right to control our adoption process, to regulate tribes within our borders and their members. We don't want the federal government with its stupid treaties and laws and regulations to get in the way of our sovereign interest. That is exactly what the state of Georgia said in the 1820s when it started to abolish Cherokee tribal councils and seize Cherokee lands. There's nothing new under the sun here. It's just that Texas has much better lawyers today than Georgia did in the 1820s.
And we should say that the reason why Indian law is essentially, or that relationship is ensconced in the Constitution, is because they found that under essentially the Articles of Confederation that it doesn't work. Like, you can't have two entities that are dealing with what is essentially another sovereign nation or a series of other sovereign nations. Can't have the states interfering here any more than, like, we can have the states saying, well, we've cut a different treaty with Mexico, or we've cut a different treaty with Canada than what, they've done, those pencil neck geeks in Washington have done. You can't have that.
Yep, that's right.
I mean, so this was explicitly to say states don't have authority to do this.
I know that I just said history doesn't provide right or wrong answers, but this is one of those rare instances in which history provides what comes very close to a clear answer. Like you said, Articles of Confederation split regulations over Indians between states and the federal government. Doesn't work. States start seizing tribal lands. Constitution says, okay, we aren't doing that anymore. We're withdrawing this power from the states. They don't get to regulate tribal affairs. Only the federal government gets to do this. And here we are in 2022, and the state of Texas is basically arguing that the Articles of Confederation should still govern this area.
Let's move on. What was your sense? I mean, where are we with that case? That was argued, I guess, on election day, right? Was it on the 8th?
The day after election day.
Okay.
So Gorsuch is really good on tribal affairs. If we only had RBG back, this case would be a slam dunk for the good guys. I think that Kavanaugh and Barrett and Roberts are uncomfortable with what the plaintiffs are asking in this case. But I also think that they are sympathetic to the white families that want to take these kids away from their tribes. I mean, look, frankly, Roberts and Barrett adopted children. They feel very strongly that adoption is a positive thing and a good thing, and I don't fault them for that at all. There is some talk among the native law scholar community that could color their view of the law here. I don't know which way this case will go. I think I'm skeptical there will be a maximalist decision one way or the other. I think it's very possible, though, that 5 justices give states this right, contra federal law, to start taking away these kids and adopting them out to white families.
And then it's just off to the races with these corporations who begin to use the principle developed that allows for that to happen, for these corporations to do the same thing basically with property.
Exactly.